if you look at it, everybody thought this young lawyer named Baez was, out of his league with this veteran 30-year prosecutor named Ashton, and yet he systematically picked apart the prosecution's evidence.
Well, he did, and the initial impression I had at the point that the trial began was that he was not that experienced, and I think his profile indicated a lack of experience. However, I thought he did a very good job. He was very methodical in his approach to cross-examination. A lot of cases can be won by the criminal defense on cross-examination. The defense lawyer hammers away at the prosecution's evidence bit by bit, and through cross-examination he erodes the state's case. Now, in my view of the case, I had the very strong opinion that she was guilty. However, my opinion is worthless. What's important is the 12 people sitting in that jury box. Their opinion matters. Really, my opinion doesn't. But certainly there are other factors that played into this peculiar case. I really think the one initial factor was the charge of first-degree murder. Perhaps it would have been better for the prosecution to charge second-degree murder, not go for the death penalty, but go for a conviction and go for life imprisonment. Perhaps the death penalty in this case was overreaching based on the extreme circumstantial evidence, plus the lack of an opinion as to cause of death, the lack of any definite forensic evidence to link her to the killing of this child. Maybe a lesser charge of second-degree murder that carries life imprisonment, or a charge less than one that carries the death penalty might have been more appropriate. Of course, hindsight's 20/20, and I think there are some who might say, well, the DA might have shown lack of confidence in his case to not go for the highest charge, and it's a charging matter by the DA. The DA decides in the state of Florida and every state who, what, when, where, and how to prosecute. And that's the charge that they chose to go with. And in my opinion, I think in retrospect, and as I think about it further, it was overcharged.
So the actual charges against her, the first-degree murder, then with looking at the death penalty, one thing that we have not really talked about are those jurors, those 12 members of the jury who were sequestered and had to go through 6 weeks. Did it come, and I mean, as a judge, and you preside over jury trials, is there a time when the jury just gets tired and says, I'm just tired of it, and I've seen as much as I really want to see?
Absolutely. Let's think about this for a second. You have citizens who are taken away from their lives, their families, their work, their loved ones, their hobbies. They are prohibited from communication, any meaningful communication with anybody other than the other prospective jurors, and of course they cannot talk about the case until they've heard all the evidence and they've been instructed on the law. Now, the ordinary citizen is really okay and can handle that for a short period of time. However, the longer it goes on, the more difficult it is. Imagine if you could not contact your wife for 6 weeks. You could not contact your children for 6 weeks. You begin to wonder, well, how are the bills being paid? What's going on at home? How's my family? Am I going to get fired from my job because I've been away from work now for 6 weeks or 5 weeks or 4 weeks? And you cannot communicate with your boss to tell your boss and advise that person how it's going. Imagine the pressure that places on a person. Plus, you eat with the same people. You eat the same food generally. You're under the supervision of deputy sheriffs, bailiffs, and I understand the bailiffs did a great job in this case, as do the bailiffs here in Caddo Parish in a death penalty case. But once a death penalty case begins, once that jury is impaneled and sequestered, my job as a judge is to make sure they hear the case as much as they can every day. I mean, from say 8:30 in the morning or 9 o'clock in the morning to 8 o'clock at night. And I prosecuted a death penalty case in 1990, and it was 23 days long. So it's 23 days from the time the jury was sequestered to the time they were released, and it was extremely hard. But we worked from 9 a.m. to 9 p.m. each day, including weekends, with the exception, I think, of Sunday mornings. We may have begun on Sunday at noon or 1 o'clock and gone to 6 p.m. on several Sundays, but otherwise 9 to 9. And I think that with this jury, it plays on them, and it's just more than they can handle, I think, generally speaking, to go into a third week, a fourth week, a fifth week. I've had sequestered jurors a number of times, at least 8 or 9 times as a judge. I feel like they're under my custody and control, and I've got to be as kind to them as I can while doing my job. But I can tell you, it wears on them. It is really tough on them. And I think it may impair their normal thinking to some extent by the beginning of the third week or the beginning of the fourth week, or God forbid we go into 5 or 6 weeks. The longest trial I've had sequestered in Shreveport has been 2 weeks as a presiding judge, and then that one as a prosecutor for 23 days.